Ramada. So I'll be your moderator for this panel. Maybe I'll just introduce myself. I'm Pin Ping, a partner with the Bird & Bird's office in Singapore. I'm an IP lawyer, and many of our clients are in the technology sector or telcos and media companies. So the topics that we're going to talk about today are quite close to my heart. Maybe we'll start by getting each of the panelists to give you a more in-depth introduction about themselves and what they do at their companies. Starting with Stanley.
Hello, good afternoon, everyone. I'm Stanley. I'm the head of legal for Menarini in the Asia Pacific. Menarini is a pharmaceutical company. It's privately owned, headquartered in Florence, Italy. In the Asia Pacific, we are present in 13 countries across the APAC, including India. We have quite a broad portfolio of products, medical products. Some of our strengths in our therapeutic areas, our core therapeutic areas would be in cardiovascular, oncology, derma aesthetics, gastrointestinal, and also respiratory. In India, we have had quite a long presence in India, and recently we remodeled our business in India. It is now a focused derma aesthetics company. So, our business in India focuses now on dermatology and skincare products, and it's doing well. There's a huge demand, to my surprise, actually, for derma cosmetic treatments, and therapies in India. So, thank you. I look forward, to speaking and with as many of you as possible after this session. Thank you.
Priya.
Very good afternoon to all of you. And I know the post-lunch session can be quite stressful, so thank you for bearing with us and being here. My name is Priya Mahajan. I head public policy for Verizon. I'm also in a dual role. I support regulatory affairs as well. In my role, I work with policymakers and regulators and trade associations on digital tech policy issues for our company across the region. My remit is for our key markets in the Asia Pacific region. A little bit about Verizon. I'm sure you all know of Verizon in the US. So we are a telecom company and a technology company indeed. But outside of US, very interesting to note that we don't operate in the consumer space. So you won't really hear about Verizon in the consumer space, but what we really do is provide services and power some of the big enterprises, large enterprise. So our remit is largely B2B space. So typically a Fortune 500 company who has hit global operations would be, we would be the provider of choice for them from a technology point of view. In terms of today's panel, I'm really excited, but one thing I would really be interested to know from you all is how do you see from a technology standpoint the data privacy developments that are taking place, which is the area that I would be speaking on. So I would be really happy to take your questions and more interested to know what you would like to hear from us. Thank you.
Ezra.
Hi everyone. It's a pretty good turnout for a post-lunch conference. So I'm Ezra. I'm a fintech lawyer. Have been in fintech for about 5 years now. I work at Tazapay. Taza is fresh in Hindi, as many of you know. Bohot acha. What am I supposed to say? Yeah. So here to discuss a few issues in relation to fintech. Thank you very much.
We have Priya from Amazon.
Hi everyone, my name's Priya. I'm a senior counsel at Amazon. I support Kindle and Alexa. So please don't come to me with complaints about your favorite products not being available on Amazon and how you love Shopee. Everyone should only shop on Amazon. That's a plug for my company. I was in private practice and I moved to Amazon about 6 years ago now. This is my first in-house role and I focus on IP and contracting.
Tushita.
Hi everyone. Very nice coming here, reaching here and being on this panel. Very nice to meet everyone and I'm looking forward to meeting you all post our discussion. I'm Tushita Kochak. I'm a partner at LCT Law Offices, which essentially stands for Law Compliance and Technology. We are in the technology space. We were a majority of our clients are in the tech space. So be it across the spectrum, it's sector agnostic. I support specifically on M&A, on PEVC deals, as well as on data privacy related requirements and compliances therein. We also support on legal audit requirements. So looking forward to this panel discussion and to meeting you all post this discussion. Thank you.
Thank you, panelists. So we have 3 areas to discuss today. As many of our panelists here are data privacy experts, so I propose to start with that area. Maybe we'll get Tushita to kick us off. Tushita, I understand that in India, there's recently been some proposed changes to your data privacy laws. Can you take us through?
Yes, that's right. So just to give you a brief background, I'm sure the Indian counsels who are here would know about the history, but just for, just to give a background to everyone about this. So we essentially currently have the Information Technology Act and rules, which cover data privacy in India. However, keeping in mind how in the last, of course, when the law was promulgated, it was very effective for that time. It's more than 10, 12 years old. But there has been so many changes with respect to the quantum of data available in the market, as well as the number of devices everyone has, and the amount of data that every user generates. So keeping that in mind, there are also certain risks that come with that, and also implications as to how that data can be perhaps misused. And keeping that in mind again, the Supreme Court of India decided, and they sort of upheld that data privacy, privacy is essentially a fundamental right now. And currently, earlier it was only a statutory right as per the current regulations. So accordingly, the Sri Krishna Committee report was, they shared their feedback, and a draft bill was tabled in the parliament in 2019, and it went to the Joint Parliamentary Committee for their, for their feedback and for their comments. Thanks to COVID, of course, there wasn't, it sort of got delayed. But finally, the report came out along with certain amendments to the draft, regulation, and in December 2021, post which it was decided to pull that back and to come up with a new regulation. And I think the new regulation just came out last Friday. It's not a regulation yet, it's a draft bill. It came out last Friday, and there are some key changes, and we are just very happy that it's come out as quickly as it did, within 3 months of the previous bill being pulled back. And there are some very positive changes, and it's a very simple bill, and it's quite concise. And I think a lot of issues that were highlighted in the previous draft have been looked into in this version. So which is a happy situation for larger entities that process data. So just a couple of, I think that's like a broad overview. And of course, in addition to the usual principles of storage limitation and consent and notice and the whole mechanism therein, there are also, in addition to that, there are also like additional provisions with respect to cross-border transfer of data. And as well as in case, if there's a minor, in those situations, there are certain provisions incorporated. For example, in the event of the death of an individual, they can nominate, death or incapacity, they can nominate someone else to basically exercise the rights of the data principles. So similar provisions have been captured. Perhaps we can do a deeper dive during the panel discussion on those. I know there was some points you raised on the look. Yeah, that'll be good to discuss as well. So, all right, thank you.
Maybe Priya first. So Priya, sorry, not Priya. Priyanna was sharing with me earlier on that some companies were lobbying on some aspects of the data privacy bill, including the age of minors, right? Maybe you can share with us on that.
Yeah, so just maybe picking up from where Tushita left off, right? So there were expectations that there would be a major overhaul of the data privacy law and it would change shape based specifically on the background, on the back of lobbying by various tech companies, specifically social media platforms. One of the things to note is that the Indian legislation draws primarily from GDPR. There were expectations that it would maybe come closer to COPPA, which is the US privacy legislation, but it seems to still be closer to the GDPR framework. One of the things that I was talking to Pinping about was the age of consent. So under COPPA, 13 is the age of consent for data tracking. Under GDPR, 16 is the age of consent, though every state could actually legislate and make it lower, but it cannot be reduced below 13. There are other countries in the world which have also adopted 13 as the age of consent. South Korea is a prominent example. India, there were demands or other requests from various social media companies that 13 should be the age of consent because you can then track data, you can also advertise and promote products to children if they are over the age of 13. But this legislation has again reiterated that 18 is going to be the age of consent. There are obviously people in India who have said that it would not have been possible to change the age of consent in India to lower it to 13 or 16 without a corresponding change in the Indian Contracts Act, because the Indian Contract Act says that 18 is the age of majority and below 18 you need the consent of a parent or a guardian. So it was interesting to note that despite a lot of lobbying, one of the very prominent asks from tech companies has not been accommodated. The other one that I could probably briefly touch upon is really data localization, and we can speak a little more about that. There were expectations that data localization would be abandoned, or again, not expectations, but hopeful expectations. That has not been the case. There has been some leniency in the sense that you could send data over borders for processing, but there is still a lot that needs to be unpacked about whether you need to necessarily have data mirroring, so you must have a copy in India, but you could also send data overseas. Yeah, and very happy to chat with people after the panel as well if there are questions, or it's very interesting how different companies have their own imperatives and based on how they process data and how they feel it increases compliance costs, right? So one of the reasons why everyone was talking about lowering the age of consent to 13 would be to make it kind of like a global standard that 13 is acceptable, and India's clearly said that that's not acceptable for India.
I think an interesting quote that I picked up from an earlier panel session is, if it's too expensive to comply, then you can do otherwise and maybe not comply. Yeah, but I understand that Priya has some thoughts on the area of data sovereignty.
Yes, I think that's a very nice segue to what Tushita and Prerna have already kind of outlined for everybody. As I mentioned, from a global technology providers and telecom company providers perspective, in addition to the issues that were outlined by the other panelists, I think all of us would agree that data is actually really, really critical to power some of the other sectors of the economy, right? Digital sector in particular. And as a global technology company, to be able to provide some of those innovative services to our customers and to the users, we really need the policymakers to pursue policies that enable cross-border data flows. But what we are really seeing from a technology perspective, from what we have seen early trends, that policymakers are actually now in the process of either brushing up their existing laws or making some amendments to introduce some kind of data localization or data sovereignty kind of requirements. My colleagues have already touched upon the trends in India, and we are early stages, and the draft bill has already come out for public consultation. And I tend to agree with Prerna that this is definitely improvised version over the version that was in the works earlier, but I think a lot needs to be unpacked. So what I am going to share over the next maybe 5 to 10 minutes is more about our experience working in the other global markets, especially in the Asia-Pacific region, how we are seeing some of the trends emerging which could be problematic and troublesome, not only for us as a technology company, but also for the users who probably would be deprived of the new age services, innovative services, because of the barriers to data flows. In terms of the key trends where we see things going from a policy perspective, we essentially are seeing 3 trends that are emerging in the region. Now, the first trend that we are seeing is more around data autonomy. And by data autonomy, I mean policymakers are enacting policies wherein they want all kinds of personal data of the users to be in country, stored in country, hosted, nothing to go out even for processing purposes. And one classic example of that is what we have seen in terms of the data security law and the CSL law in China, wherein certain sets of data was subject to additional assessment by the state administration before it could be sent outside of the country. So I think that's one trend that's of concern to global companies who are not able to transfer data and not able to leverage data in a seamless manner, and thereby breaking the whole supply chain. The second big trend that we have seen emerging is more around data sovereignty. And by data sovereignty, I mean it's not all kinds of data that is basically restricted, but data of a specific kind, which potentially could be financial sector data or health sector data. Now, what the policymakers are doing is basically enacting barriers to sharing that data across borders on sovereignty grounds. And interestingly, I came across Australia as an example, which otherwise has had a mature data privacy law since 1998, if I'm not mistaken. But at the same time, it is not allowed for the providers to basically share electronic health information or transfer the data outside of Australia because of, again, sovereignty reason. And the third example that I have is, again, it goes back to India, where we have what we call data mirroring requirements. Even before the data protection bill was enacted, we had the sector-specific requirements, wherein, for example, the Reserve Bank of India had enacted a law wherein the payment service providers were actually allowed to transfer data only if there was a data mirroring happening. And what we have heard on the ground and in our discussion with industry colleagues is that it ultimately ends up putting a barrier to the providers. At the same time, there's so much cost attached to storing the data onshore and so on and so forth, that it ends up in de facto being a data localization measure by the policymakers. So I think these are the 3 emerging trends that we are seeing, which are probably of concern to us as an industry. And what we really should be doing is to inform the policy discussions, work with the policymakers to ensure that some of these barriers can be relooked at, reviewed, and work with the key stakeholders on kind of bringing about a change in them. I can talk a bit about some of the policy principles that we should want to promote, but maybe I'll keep it for the next section then.
So maybe we'll get, so thank you for that. So you'll get Stanley and Ezra to share about their privacy challenges in their respective areas. So maybe Stanley first in the medical area.
Sure, thank you. So Menarini is not a tech company. We are a biopharmaceutical company. So we don't have that same regulatory scrutiny, that spotlight that's shining, from the data regulators on companies in the tech sector, like your Amazons, or even in China, right, with your Alibaba and your Tencent. But in line with what Priya said earlier, one thing that for someone like me, as a regional counsel, even developments, personal data laws in our local affiliates, while they may be domestic, they may be local, they also, concern me, and I need to make sure, that, I am, myself and my team, we are on top of that. And one example is, you see this trend of extraterritorial application, extraterritorial reach of data privacy laws. And that's happening now. It's in the GDPR. Last year, China released new data privacy laws came into force in China, which also have extraterritorial applications. Yeah. So for a company like Menarini, with regional holding entity in Singapore, with operating affiliates and trading operations across the jurisdiction, we do receive the personal data of individuals from the PRC, whether it's our employees in our China operations, or healthcare professionals or doctors, yeah, in China, and that comes through our regional holding entity, either the regional HR team, the regional marketing teams. So we need to make sure as well, even though this is a Chinese data privacy law, we need to make sure that on our side, right, and also with our local Chinese affiliate, the measures, the safeguards are in place to ensure that before any data of Chinese individuals are transferred outside to Singapore or even to our headquarters in Italy, the requisite statutory requirements have been fulfilled. And this could be like data impact assessments, the signing of a data transfer agreement, between the transferor and the transferee. And I'm sure, right, within this group today, there will be, companies as well in India, right, that may, be affected by, these foreign data privacy laws that have extraterritorial effect. The other thing we realized, and I've seen as well, is that within the Asia Pacific region, there are many countries or jurisdictions are now taking data privacy very seriously. So just this year alone, Thailand and Indonesia have essentially passed into law data privacy laws, right, in their respective countries. Some of these also have, data, extraterritorial effects, maybe to a lesser degree, not as intense as what you have, what you see with China and the GDPR. But certainly, right, in my view, from my observation, even if you're not in a telco, in a tech company, or in a company that there are heavy collectors and users of personal data, as general counsels and as in-house counsels, data privacy is probably that one fundamental core skill set where we must have at least a baseline understanding and know-how of fundamental data privacy concepts and safeguards. Thank you.
So I think in fintech, it's actually one of the more challenging areas because it's both finance and technology. And for most fintechs, you will end up becoming regulated by a financial regulator somewhere. So whilst Tazapay doesn't work directly with RBI, because under the new rules, we are considered a payment aggregator, the only thing we need to comply with is cybersecurity rules, okay, which we already do because by virtue of us applying for a license in Singapore, we already have to comply with MAS, Singapore Financial Regulator, MAS own cybersecurity rules. So in terms of data transfer, the way startups and fintechs try to deal with this is to structure your product properly. So by what I mean by that is that our platform service, the platform terms and conditions, is actually between the user and Tazapay Singapore only. And then Tazapay Singapore would be authorized by the user to engage any of its subsidiaries in any of our active countries, such as India, Canada, US, Europe, and then we engage our subsidiaries to perform the necessary services. But the data contract between the user and the platform is one with a Singapore company governed by Singapore laws and subject to the scrutiny of the MAS. And by virtue of being here, we comply with the PDPA, the Personal Data Protection Act in Singapore, which is actually a pretty good and fair regime. It's essentially consent-based. It tries to take into account data protection for users as well as the needs of the business. So I would say in fintech, whilst sometimes we will see data breaches from time to time, especially from the large tech companies, in finance we are a bit more careful in the sense that we are aware that if there's any data breach, it will severely impact our users. Whilst we have seen some fintechs experience data breaches, I think some of the Indian fintechs have experienced some of that. It is still a relatively, I think companies are still not very used to ensuring that our system is strong and is sound. Like for us, we rely mostly on the cloud, and we use AWS protection, and all our files, our folders are all access controlled. So we follow the market standard practice, whereas a lot of regional startups, they are perhaps in lesser regulated jurisdictions. They tend to be not so familiar yet. So I think it takes some time for the industry to catch up. But that being said, the thing about data protection is that a lot of the times the user doesn't experience it, the damage. They don't know how it impacts them. And because the user doesn't know how it impacts them, in terms of enforcement, it doesn't come from the users themselves. It comes from the government only. And apart from certain countries like the EU, where data is paramount, the enforcement is actually quite weak. Yeah. So that actually gives more space for us to get up to speed. But there needs to be a stronger push from regulators in certain countries in order for companies to do so. Yep.
Just wanted to add, as you mentioned, I think what we are seeing is not only horizontal data protection laws being enacted by some of the countries in the region. You mentioned about Thailand, that's a good example, Indonesia, Malaysia. But what we also are seeing that some of the matured markets in the region, like Singapore or Australia, who already had a very robust data protection law, are actually going ahead and doing some amendments to align with the emerging realities of the tech sector. And interestingly, you brought about the issue of breaches, right? And what we are also seeing, a new trend emerging, that a lot of these countries are actually enacting data breach reporting obligations. And today what we really have is a standard called the GDPR standard, where you have a 72-hour window to report your breaches, subject to certain other conditions being met. But what is really troublesome and of concern potentially to the business is also the fact that in the Asia-Pacific region, regulators are taking diverse approaches. So there's no one-size-fit approach as it relates to breaches, and if you are a global company working on a global scale, then you really have, the lawyers will be busy or in navigating through different breach reporting requirements and so on and so forth. So I think that's one area that we probably are closely monitoring as lawyers, and making sure that at least there's some kind of harmonization in place for some of those reporting requirements. Thanks.
I completely agree with that, and yes, we have been seeing that across the board, and even for, the previous bill that came out, for 2 years, 3 years, all our clients were just scrambling to try to sort of keep up, and it was very clear that it would be enacted, but then it was pulled back. So, but then the good thing, the outcome of that was a lot of companies are sort of, from a GDPR standpoint, they have taken measures, taken actions to ensure that, they're taking the steps to protect the data or the data principles. But of course, moving forward, I think it'll be very important that in addition to, of course, protecting and safeguarding the data principles data, it shouldn't be that compliance, it gets so onerous for data fiduciaries to comply that they just decide that, okay, let's just see what happens, like you said, and there are penalties, even for the Indian regulation, the draft bill, there are the high penalties, but there should be some uniformity where possible, so it's easy and it's convenient for companies to be able to comply, and it's practical. So that is something.
Also unique about India is the concept of data fiduciary, which
Yes.
we haven't seen, at least in my knowledge of the data privacy laws.
Yes.
The concept of data fiduciary is very new. So what we really know as people who've been following privacy is controller and processor, right? But this fiduciary is a new concept, and it was also there in the earlier bill. So maybe Tushita and Priya, you guys can touch a bit upon how do you see that fiduciary playing out vis-a-vis a significant fiduciary, which was there in an earlier bill, and between the controller and processor, how do you see that aligning with other data protection regimes in the world?
I think I'll just start by saying that, this is another example of how the Indian legislation or proposed legislation actually seems to build on GDPR but is not a copy completely of the GDPR, right? So you have similar concepts such as data processors and data facilitators, but then by introducing the concept of a data fiduciary, it actually imposes a higher burden. And then, of course, you had the concept of, significant data fiduciary. And what does that mean? Because they were basically trying to pin the blame on someone, and you were under an obligation to do more than what other companies would be doing, right? And you can see it in different parts of the legislation, right? So, for example, you build on the data protection officer, right? And then there's a grievance officer. So you've kept on adding to it, which goes back to the point about compliance. Ideally what you would want to have is a global regime which is easy to understand and which looks, which for companies is easy to understand, and for customers it's easy to understand. One of the classic examples of GDPR failing is the cookie policy. So every single time you go to a website, if it's hosted in the US, in Europe, you will have this elaborate disclaimer about cookies, and how many of us really read it? And then you have to opt out. Why should I have to opt out? Why couldn't it have been the other way around? I opt in if I want you to track me, otherwise assume I don't want you to track me, right? If the idea is that privacy is important for me, don't track me. Take my consent to track me. Why do I have to keep opting out? Because, inertia. There are so many people, especially if you're not a legal professional, who have never opened the cookie policy, who have no clue what's going on, and then they will say things like, I don't know what's going on. Maybe Google's listening to me. They know I'm planning a holiday to Europe. Well, they are not listening to you. You are leaving breadcrumbs along the way, and they are just putting together that story, right? So, sorry, I kind of digress there with the cookie policy because that's like a pet peeve. I'm one of those people who will start, I have to factor in that additional 2 minutes to go and read the policy and switch off everything and opt out of it. But that's why I don't see targeted ads, right? My Google is very clean. Like when I log into my laptop, there are no ads for things that I've purchased in the past or things that I'm planning, right? And then people have this thing about Insta is listening to me and Facebook is listening to me. Privacy is also in your hands, right? So obviously the government's doing a lot. There's a framework that they're building up, but all of us also should maybe consider what we're leaving around for other people to track, and just take that extra moment to read the cookie policy. Sorry, just gonna hand it to you, Tushita.
Just to add to that, I completely agree, and I do the same. I review all the TNCs, and I look at the cookie policies, and I opt out. But yes, a lot of people, I guess only lawyers do that. Yeah, I don't think anyone else does. But I think from an India law perspective, I think they have tried to simplify this in a way, because now it's essentially what they're proposing is just to look at the what and the why, which is what data is it that you're looking to process, and why you want the data, for what is the purpose of that. So I think that really helps. But let's see how the consultation goes. It's open till the 17th of December, I believe. So let's see how that goes, and then we can, we'll get some more insight.
Thank you for that. Before our panelists get more worked up over data privacy, maybe we can move on to IP. Stanley has
Just one last
more.
point. I mean, I'm hearing about some interesting themes about harmonization, standardization of data privacy regulations and laws, right? So I've thought about that, and that's a real issue facing in-house counsel in my position, where I have a regional coverage. And you realize immediately, right, Asia Pacific is a challenging backyard environment to operate in. We are not homogeneous like the EU. So the GDPR works in the EU because of the EU, right? The whole concept of, the EU, right? The EEC, the European Parliament. So there are all these frameworks and institutions, right? That allows, right? These European, one, GDPR standard, and that's easily applied, right? And interpreted and applied across the EU. We don't have that in Asia, in Asia-Pac. It's a diverse region in terms of linguistically, legal systems, right, political systems, even the levels of economic development. So for companies like us, who are operating in Asia Pacific, you've got your local laws. You've also got these foreign laws with extraterritorial application like the GDPR, or even China's personal information Privacy Law. And I think, the practical approach, right, as opposed to hoping and praying, right, for something similar to the GDPR in the Asia Pacific, I don't think that's going to happen in my lifetime, is to just, peg yourself, to the gold standard or the highest standard. So it's just like, in bribery and corruption, you have got the FCPA. I think, generally the GDPR is recognized as the international, gold standard, for want of a better word. I'm lucky, Menarini is lucky, we are an Italian company, so, we hold ourselves, to the GDPR. And from a practical standpoint, we apply the GDPR standard across, our affiliates in Asia Pacific. That makes sense from a consistency, from an application implementation, standardization standpoint. But the downside to that is, we could be setting the bar too high in some of our affiliates. Yeah, and that may not be good from a business standpoint, right? You are introducing unnecessary, measures or safeguards, which are unnecessary, right, according to local laws. But, short of having a GDPR, right, in the Asia Pacific, I think this is the practical solution to take. It's just apply, a recognized, internationally recognized or accepted standard, right, whether it comes to anti-bribery, anti-corruption, or in this case, data privacy.
I just want to add to what Stanley said about we not having a gold standard in Asia, and I totally agree with what you're saying in terms of harmonization. But I also see that there's a lot of policy impetus being given by the policymakers, and Singapore is a very good example of the PDPA, which is the Data Protection Authority here, and the regulator here, looking at some of the alternate to data transfer mechanism. For example, they are working with other ASEAN markets on developing model contractual clauses or some of those frameworks, which could be potentially an alternate to other frameworks. And another example, classic example of an alternate but industry-led voluntary framework is the APAC CBPR, which is the Asia Pacific Cross-Border Privacy Rule. So I think there are frameworks available, but because they are flexible, they are voluntary and industry-led. So we don't see a lot of adoption happening. So that's probably a question for all of us to consider. Do we really need GDPR like gold standard, as we say, or do we need more flexibility and voluntary frameworks which are more industry-led and meaningful? Thanks.
Thank you all for that very passionate discussion about data privacy. Can we bring the same passion to the discussion about IP, which I guess is our other big topic here? Maybe I'll start off by just giving you a brief summary of the recent changes to the copyright law in Singapore. So it was quite a big change because it's essentially an overhaul of our copyright law, and a number of completely new provisions were introduced, including a new exception for text and data mining. There are provisions that flip around the position on default copyright ownership for commissioned works. There is an introduction of a new moral right to be identified for authors and performers. And then also some additional enforcement measures for against people who sell set-top boxes and related services. So if you want more information about that, we can have a chat later. But I think the problem with IP, it's a bit similar to what Stanley described and Priya described about data protection, which is that the standards and the laws and the tests are quite different in the different jurisdictions in the region. When it comes to enforcement and protection, there are difficulties with, and you can't really use a one-size-fits-all approach. I think maybe, so I'll throw the floor open to our panelists to see if they want to share anything about the difficulties with enforcement or IP protection in their respective areas. Maybe starting with Priya. Oh, sorry, Priya, no.
Thanks. Actually, I have a question for you about the commissioned works piece, because I found that really fascinating, and I saw a lot of people are very upset because of the whole, photography shoots that are so popular in Singapore, and how it means that copyright rests with the photographer, and you actually have to ask them to not use those photos, and they've been charging more to actually give you copyright back, right? As a lawyer, what do you think about who does copyright vest with, right? Because the subject is a person whose photograph's been taken, and copyright now doesn't vest with them, it vests with the artist, even though it's a commission work, which is always, at least in the American framework that I'm more familiar with, it's the person who commissions who owns copyright. And that's like, a creative services agreement or a work for hire arrangement as it's known. Why do you think Singapore flipped that provision?
So the thing is that Singapore flipped that provision not for all types of commission works. The original position is that only for certain types of commission works, like I can remember photographs, engravings. Yeah, I think there were a few categories, including sound recordings and also films. And so the recent change, it was just to bring these categories of works in line with other types of commission works. And the biggest hoo-ha came from actually wedding couples who think that, why should my wedding photos belong to my wedding photographer? And we actually did some advice, like the photographers who have now some disputes with the wedding couples who insist on ownership of the photograph. So I mean I think. So that's actually, but that's not, that's a lot of, that's the issue that came up a lot in the press. But in terms of areas of changes that affect businesses more, then it would be the TDM exception and maybe the one about needing to identify authors and performers that are more crucial, because I think especially the one about right to identification, it really means that if I were to commission somebody to, let's say, produce a piece of artwork or something for, let's say, a brochure that I want to publicize for the event, I'll have to put his name on the brochure, but there are concerns about how, there may not be enough space on the brochure, or the artistic things, I don't want to put a name. So then it's important for businesses to be mindful of the need to put in the contracts that, okay, there's going to be a waiver of your right to be identified if they don't want it to be there. So that's the practical consideration.
Yeah, that's interesting. The reason why I ask is because for me, it actually goes back to privacy, especially in the context of wedding photography.
Well, back to privacy, guys.
Unfortunately, you can't take the privacy lawyer out, but just moving on from that in terms of IP, just generally, because you mentioned that, I think at least the work that I do, I am an IP lawyer as well. One of the pieces of work that my team looks after is just takedown of content for IP infringement. And we were chatting about it earlier. Social media platforms is rife with IP violation, as we all know. And the US has the DMCA, which which provides for the takedown of content. And I think it's an open question whether it's actually a process that's working, because again, going back to harmonization and what companies are doing is all very piecemeal. While in the US you have the DMCA requirements, in the region here there is no specific legislation that requires takedown. There is no specific time frame within which a particular violation must be reported or acted upon. So you're really at the mercy of the platform or the agency where violation has taken place, right? So let's say if I'm an artist and my painting is copied and it's floating around on WhatsApp, people are sharing pictures of that. If you reach out to WhatsApp and ask them to take it down, there's an email address if you go to WhatsApp where they'll say, please send us an email, we will do our best to take it down. In practice, it's not that simple, because your email is probably going to be lost in the number of emails that WhatsApp receives about violations. Your violation may not be the more egregious, because it's just IP violation at the end of the day. And in the region, for example, people who've been tracking news know that Facebook and WhatsApp have been in the news for hate news, hate speech, fake news. So if there are emails that they receive about taking down content for those reasons, that's probably going to be prioritized, right? So I feel like IP violations when it comes to some of these tech companies are probably not a key area of focused right now. And for those who are at the receiving end of it, people, whose books have been pirated, there are also instances of people whose music has been pirated and it's available on WhatsApp, Telegram, to just a couple of the channels. It's not easy to actually get action taken. So just talking about a case law from India a couple of years ago, there was a movie that was literally broken into 2-minute snippets and it was shared over WhatsApp. WhatsApp didn't do anything. When the company complained, it was I think it was a cable news channel, ZTV or Star, which had actually produced the movie. They actually had to go to court and get an order. And even then, all that the court was able to say was, these are few accounts that have been identified as sharing this content, so please suspend those accounts, right? Because WhatsApp said, well, hey, I'm encrypted. I don't know who shared what. I cannot de-encrypt my chat, so there's really nothing I can do. So when you're talking about IP violation, especially in the context of, encryption and all these websites and social media channels, I think there's a lot more that we can talk about, and we'd probably need an entire panel alone to chat about that.
Just want to respond to something very interesting you said in terms of the liability for content, right? And as a technology companies, we are flat. What we really and very jokingly say that we are just fat pipe providers, right? We don't really monitor, and we are not allowed to monitor content on the networks. And to me, another concern that we increasingly, and a trend that is emerging, is the dilution of the safe harbor liability. As you all know, as a technology company, when we don't really monitor or track content, then it is important for us to continue to have that safe harbor exception for any liability that may arise out of content that's transmitted on the network. So I think that's also an important discussion that should be and taken up with the regulators, as they are increasingly lifting the not the corporate veil, but the safe harbor veil, and just looking at who's doing what and looking at the traffic packet is something that is beyond our remit. So yeah.
I'm also curious about the concept of moral rights in Singapore with respect to similar, what you mentioned with respect to the photographers having the right to the photos, and similarly the media, audio, etc. So how does that work? If you could just give some insight on that, that would be great.
Well, so currently the default position has been changed. The photographer owns the rights, but that can be overridden by contract. Yeah, so if at the point of contracting, if the customer is not happy with that, then you can say otherwise. But I guess then, because the default position is that the creator owns the thing, so he may ask for more money. Yeah, so I think Ezra has something to share.
Yeah, so following from that point, actually, most likely when content creators are going to contract with companies, the companies will almost always want them to waive these rights, because we are paying for it. We are paying for their work. So almost all the time, they will not have the right to be attributed. They will not have the ownership of the content that they make. So in terms of risk to company, I would say it's quite low. But if we go back to the principles of IP enforcement, actually it is in a very similar space as data protection, because for most developing economies, it is not priority, even for Singapore. It is only very recently when Singapore started to help to enforce breaches against IP. For instance, a few years ago, there was a movie that was being shared illegally and torrented, and then the lawyers got the court order to actually track down who these individuals are. But the ISP, I think it was Singtel, opposed and said that this goes against user privacy, would not allow it. Went all the way to the court, highest court, I think. And also, recently there was an enforcement measure on clamping down illegal set-top boxes, because these set-top boxes actually allow content that is IP protected to be shared, in the breach of intellectual property. The problem is, right, enforcement of IP essentially depends on the owners themselves, but the owners of the IP have limited resources. They already have a huge team to find over the internet in all countries on where the intellectual property is being abused. And there's a limit to what they can do, right? Because, resources are sometimes better off spent producing more new content, growing market base, instead of clamping down on pirates. So essentially, it's actually very hard to control privacy through channels such as torrent. Even until now, so many years later, governments are not able to shut it down. So I think from the legal perspective, what we need to do is to protect our own company by making sure that our own intellectual property is sufficiently protected to the extent that we can do so. Obviously, that involves the traditional methods of copyright registration, patent registration, and so on. But that being said, when it comes to piracy, I think it's still a huge challenge, and oftentimes our resources may be spent better elsewhere. Yeah.
I guess from the piracy angle, one development that we've seen in the region is that more jurisdictions are introducing site blocking measures. So these are laws that allow content owners and their exclusive licensees to go to the court to get network service providers. So these are your internet service providers to block that access by their users to certain websites that are providing a lot of infringing content. So, so many of these applications are actually championed by, there's this body called the Coalition Against Piracy. So many of their members are content owners, so that there'll be people like Premier League or The Legal or like TVB, Discovery, BBC. So they might band together and bring a single application and get a list of sites blocked. So that's been very effective because it's a no-fault regime. So we're not like saying that the NSPs are infringing or that they're at fault, right? So it's in line with the whole safe harbor concept. NSPs are not infringing, but then because you are providing the gateway for users to access this content, just go and do the block. Yeah, so I think that's a valid point. And you mentioned about internet service providers and their obligation to meet in the in-country requirements. I think India is a classic example. And again, for confidentiality reasons, we are not allowed to share. But I mean, what I have seen that some of these IPR copyright violations do get addressed through legal means, legal recourse. People approach the courts, and the courts will typically issue an order, and then that's how it gets kind of redressed. So definitely there are means of redressal, but again, there's a cost to it, which means that internet service providers have to invest in blocking tools and, of course, keep up with the increasing demand for blocking. Yeah.
Also a challenge that we've seen in India, to add to the point that you mentioned, that we need to safeguard our IP and the company's IP. So we see a lot of times it's something that's not a priority for a lot of companies, because in India specifically, if you want to file a patent, as perhaps you perhaps have a similar process in other countries, but in India it has, you do the prior art search and all of that, and then your patent has to, your provisional specification has to be published in the patent, the journal, and which essentially gives a overview of that to anyone who perhaps wants to reverse engineer and build something before your patent even gets filed. So that's a challenge that we see across the board. So we really have to have a conversation and look at the legal, business, financial risk for the company, and then analyze that, and then they take a call as to whether they want to go ahead with it or not. And a lot of times they don't want to go ahead with filing a patent. They prefer, because they just want to ensure that it's not that information or whatever, all of the details are not just taken by anyone and in some other country, just just built. And then again, there's the whole the aspect of PCT filings. So that's again a concern. They're like, okay, even if we get it in India, will we get in other countries? So that's something that we see as a challenge for a lot of our clients in India.
I think Stanley has a...
So I envy my colleagues there, they're from the telcos and the tech companies. So, when they talk about IP, it all sounds very sexy, very high tech, So let me go old school, right? So I'm not the only person from pharma here. There's Padma from BMS, Bristol Myers Squibb. And I think this morning there was a lady who introduced herself from GE Healthcare. So pharma companies, IP is important. At the core of a pharma company, it's our product. Yeah? It's that tablet, it's that pill. Yeah? And what is it, right? What's the value in that product? Yeah? It's the active ingredient. That's the secret sauce. that helps us to recover, right, or to fight, diseases and infections. But on the other side of that coin, it's the IP, it's the patent, it's the trademark. Yeah. So for sure, right? For pharma companies like mine, we are brands. We are spending a lot of money on R&D, on research, on innovation, on marketing, on commercialization. So there's a lot of value. There's a lot of value in these intangible assets, patents or trademarks. The other thing I've noticed in my role is that even for my non-lawyer colleagues, there is now a greater awareness of the importance of IP, factoring, IP considerations into business case evaluations when we're looking at, potential, acquisition or licensing opportunities. IP is now a critical criteria in terms of, getting management approvals, for proceeding with an acquisition or licensing. And I see that the questions that I'm getting from my business colleagues, from my marketing colleagues, from my product teams, it shows. It tells me that they are definitely aware of IP. They know about patents. They know about trademarks, domain names, and they're asking interesting questions. The questions are a lot more sophisticated. They're a lot more nuanced. So that puts pressure. That puts pressure on me and my team, to make sure that we up our game. For someone like me, I'm not an IP lawyer by practice. I'm corporate M&A. But thankfully, I have two members of my team who have IP experience. Yeah. So with that, it's the responsibility is on us, to make sure that we understand, right, what are the concerns, from at least from an IP standpoint, from our business colleagues, so that we can give them the advice. And one of them is like patents. Yeah. We, as a company, we are always looking for potential acquisition or licensing opportunities. Yeah. Drug products, portfolios from other pharma companies. So one question that we really need to be very good at answering, the questions that we have is about patents, right? Patent exclusivity. When do these patents expire? When do that loss of exclusivity? And that's important. And what our colleagues are expecting, and none of us in my team we are patent attorneys. Actually, Ping is a patent attorney, right? And she's pretty impressive. If you Google her, she's got first-class honors degree in chemical engineering, and and she's a lawyer as well, right? So a lot of respect for someone like a patent attorney like Ping. But so for us, none of us are patent attorneys, but we are being asked patent-related questions, and that means that we have to have this baseline, a commercial understanding of where our colleagues are coming from, right? So the key question is, we're looking at this interesting product opportunity. We want to know, right? This product is still on patent. It expires in 5 years' time, for example. Yeah, but how strong is this patent? How unique? How novel is it? Do we really have exclusivity for the next 5 years, or could next year, right? We'll start seeing generic competitors, because it depends. It doesn't mean that you've got a patent registration. You've got a rock solid exclusivity or protection. It really comes down to the scope of the patent protection, the claims being made, the exclusivity or the registration granted. So it's very possible, right, for a generic competitor, to actually start marketing, right, or making efforts, to start pre-marketing activities, even if for a product that you think or we think we have exclusivity. So it's and that's one thing that's really important for us. So making a baseline preliminary informed assessment of the strength, the uniqueness of the patent registrations of opportunities that we are considering. The other is also, for us at Menarini, a core part of our business is we actually, market and commercialize products from other pharma companies. So this is where it gets interesting. These are products that we don't own, but we have a right to market, to commercialize them, and also to use the trademarks. Yeah, some of these products, actually most of them are already off patent, and that's why the original brand owners are open to out licensing them. But here again, the commercial value of the rights that we have, it's not just the right to sell, it's not just the right to market, and to book, the sales and the revenues and the margins, but it's also, the ability, right, that freedom to freely use the IP rights that have been licensed to us. And where it gets interesting, for me, right, in my role is that we have a license to use a trademark that we don't own. Yeah. So contractually, it's important that we have the right, to make sure that the trademark owner, the licensor, has an obligation, to step in, to take actions, to defend, their trademark if there's a third party infringing their trademarks in the countries that we are selling their products in. And this always becomes a point of contention during negotiations. I think one of my colleagues actually said, that licensors, right, or brand owners themselves, they may not be interested in some of their older IP because, they've moved on. They're looking at they're developing and creating new IP. And that's, we find ourselves, quite often in that similar situation where contractually we want to have a right or place an obligation on our licensor to take action if there's a third party infringing, their IP, right? Using, their IP to market counterfeit or to manufacture and sell counterfeit products that are then, cannibalizing or eating away at our sales. Yeah, and we'll be in deep trouble if we can't impose, that contractual obligation on our licensors to take action against the infringer. Yeah, because that has a huge and direct economic and commercial impact. Yeah, and that's always, a big point of heavy negotiation, during, drafting and things like that. But it's important that we do that. The other thing is also, to enhance, the security, the strength of our rights as a trademark user, as an authorized user or licensee of our licensors' trademarks, is, apart from making sure that there are these robust contractual safeguards, written into the contract, it's also, to avail ourselves of, statutory recourse or protections. So one of them is the concept or the mechanism of a recordal. I think the IP lawyers in this group will know exactly what a recordal is. Initially, I thought that it referred, right, to recording, right, the transfer or the assignment of a trademark. And then later on, I found out, right, that there's another form of recordal, right, which is basically, right, registering, a licensee's right as an authorized user or licensee of a trademark with the local IP registry. And that's something that, we as a matter of practice now, we make sure that we also negotiate and draft into the contract a right for us to record our interest as an authorized or licensed user of the trademark. And this is important because, even if there is the contractual provisions are there, they are strong. Yeah, if there is a third-party challenge in court, and that challenge is successful, so notwithstanding, right, there is a binding contract between us and our licensor. The local court could rule, right, that the license, our license to use that trademark is essentially, right, ineffective in the eyes of the law. And that, again, as you can imagine, right, has huge, commercial impact. So we always think about risk in terms of commercial risk. Market conditions change, right? Generic competitors come in, and that starts to affect sales. Yeah, but I think the significant shift in the thinking of myself and my team in the last couple of years is it's not just these economic or commercial risk factors out there, but it could be something that's IP related. Yeah, the business could grind to a halt. The business case could just go out of the window. The minute we have a challenge from a third party on our use of a trademark, yeah, and then there's an injunction, and we essentially have to stop what we're doing. If we want to continue, we would have to rebrand the products, and that's a disaster because no one knows, right, what your new brand is. Everyone knows what the old brand is, and that's where the value of the IP is.
Yeah, actually, so Stanley, that ties back very nicely to the point that Tushita brought up about why file for a patent, right? Because you file for a patent to get exclusivity, especially if the invention is something that it might be easy for somebody else to come up with next year or 2 years or 5 years later. The first person to file for a patent will get exclusivity to exercise that invention. And then there's also value to that when you bring your product to the market, you try to license it, you can tell the licensee that, look, you're protected, for over the next few years where my patent is still alive.
That's such a good point. And just on that, we have seen for our clients where the ones who said, okay, you know what, maybe we shouldn't file a patent, but tomorrow they want to go to market and they want to launch, and then perhaps after a year they want to file a patent, and turns out it's already prior art. So it's like a catch-22 situation that happens. So we do try to advise them to, we give them the best solution possible, and analyze the legal, business, financial risks and let them then take a call. But yeah, that is a big risk. If they're not able to file for the patent at all, and it's their own IP which they're not able to utilize.
So talking about patents and risk, India is a really difficult and tough market for pharma companies. So I'm sure you know that in India, right? Your big pharma companies like your Novartises, your Sanofis, they're nobodies in India. If you look at the market research data, it's the Indian companies, your Biocons, your Lupins, these are your big boys, right? Even against your big pharma giants like your J&Js and your MSDs. So this is where in India there are lots of generic medical pharma companies. Yeah, it's a huge market in India. India is also in the world, right? India is one of the 2 top suppliers of active pharmaceutical ingredients. So this is the stuff, the magic that goes into your tablet, your pills, your capsules, right? That helps us to get well or to not fall sick. So there are IP issues of all pharma companies, right? Whether you are based in Europe, in North America, or even you're a Japanese or Korean company, inevitably, right? You'll have to cross paths, with India, whether in terms of getting your raw materials or your API supplies, or a competitor. An Indian, a very tough, right, ferocious, determined, Indian competitor. So patents, it's something which, yes, if under WIPO or even local IP regulators or laws, right? Patents, they are real. They do offer protection, but as we can see, right? And it's been the experience of many international or Western pharma companies. We do face patents do have their limitations. It doesn't guarantee that you will not face a determined local competitor, right, who can find creative ways, right, to work around or to circumvent the scope of the patent exclusivity or registration you have. Yeah. So India is still it's a huge market. You can't ignore India, right? In terms of if you are in the healthcare or in the pharma industry, but there are very serious IP related challenges, right? With operating and being successful, doing well, right? Getting a significant share of market in India.
Can I do a time check? I think we have to wrap up. So thank you, all the panelists, and you can catch us outside if you have any burning questions. Thank you.
I think there's a question from the gentleman there.
Right. There are 2 questions. Maybe the gentleman behind first. Oh, there's a mic.
Hello. Okay, the question is in relation to copyright, but not in relation to IT business. What happened was, recently we did a litigation matter we did a lot of research, then put up a case after 4 years of research, and we were successful in the case. Once we are successful, another set of lawyers started copying our documents from the litigation matter that we have done. They copied all our affidavit and start putting in their cases and saying we are the one who got everything done. I understand that court documents are public documents in a way. So is there an IP or copyright answer to this case? How can we protect ourselves for all the research that we have done? Thank you.
No, I think under Singapore law, there's the specific exception for use of copyright material when you're submitting something to the courts. So unfortunately, yeah, that may not be something you can pursue against the other lawyer if they merely use the thing for submitting to courts. But of course, if they used it for other purposes, then there might be a case.
No, I think if that is allowed, even the judgments passed in certain cases cannot be published, because it becomes a public property, because if your judgment is passed, it contains the arguments based on both the parties, and therefore, it contains a lot of details, and, that is used as a precedence by us. So I don't think, there is any law in any country which, I don't know.
I think if it's really important, you can request the court to redact. You can also provide certain information behind closed doors. For example, the court doesn't compel you to share data that would be confidential or damaging to your company. So you need to think ahead, and if you think that there's a risk of anybody copying or reusing that material, you have to make that submission before the court, because we do make filings that we request are not made public.
No, that is in the intellectual property cases, certain drawings, see, I've done it, so that has to be given to the High Court in sealed cover, and they will not allow except for the opposite party to look into it. That's a different issue. I'm saying is that, my pleadings before a court, as rightly told by him, and I think, my question is not on, I was on a different tangent altogether, because, see, when discussing the Data Privacy Act, which is in the, which came up, in the sense the bill came up and it was published, on the Indian context, which was published last Friday is concerned. I didn't have a chance to go through the entire thing, but, glanced it. I feel that, the concept as contained in this act and that particular bill, I don't think it is onerous as made up by many of us or thought by many of us. Because the earlier data protection bill, which was in Parliament from 2019, then 2020, and was much different, because it gave a lot of powers to the government to stall anything at this. This also has a power. Section 22 definitely says that government can form rules and regulations. So it has one thing is that it provides for a huge penalty rather than an imprisonment or anything. So it goes into 250 crores and 500 crores is there, and it also builds in a kind of dispute redressal mechanism here. You don't have to approach the court every now and then, but that doesn't take away the Indian writ jurisdiction. That's a different issue. But here you have all kinds of things, which I feel, I should confess that I have not gone into detail, but it is something which is much better than this. And the question whether, a person of 13 years can be allowed to give consent is something which is much, I don't think in the Indian context it can be allowed, because absolutely that's a kind of things, because if you give a 13-year-old child to give consent to something, and it leads out to social disturbances. I can go into a pornographic site and 13-year-old agrees that I'm 13-year-old, then it becomes a little different thing altogether. But 18-year-old, that's the reason 18-year-old is there. And also the world is passing through a lot of terrorism, see, in the sense, the global terrorism is now through online. It is not that, I have to meet you to brainwash you. I can do it online also. So the consent is something which we need to look into. The concept came into existence because there was a case filed. We have a called Aadhaar card or the identification card, and Puttaswamy's case is there, where it was filed whether it is a fundamental right or not, to have a privacy. And they do tell that it is a fundamental right, but with certain exceptions that the government can at any point of time change it, or the government can do anything with that. But the practical side in India is that I think, all people who are coming from India will accept it, that we, on our own, suo motu, give all kinds of details to everybody. Even a courier boy comes, I have to give the Aadhaar card. He'll ask only for the Aadhaar card. He will not ask for anything else, Or if I want to get a SIM card, I have to give the Aadhaar card. If I get to go to the post office to get something also, they will say the Aadhaar card. And so that means, see, suo motu, we are giving away our privacy. We ourselves are doing it. I think all of us, whether educated or not, it is one thing. And the last point I want to say is about RBI. You said that, RBI is concerned, it is very onerous. RBI, what says is very simple. Says your system, cybersecurity it should be it doesn't prescribe anything else. It says that, it should be in alignment with the existing law. And you should have a strong firewalls. It doesn't, on suo motu, prescribe anything. So if there is a breach, then RBI has its own mechanism. Why RBI is insisting on keeping that data a copy? It doesn't say that the entire thing has to be kept in India. It says a carbon copy of what you are storing abroad has to be kept in India because RBI wants to inspect it. So when I'm going for inspection, I can't say that it is something in Australia or in America, and therefore, I can't give it. That is the reason RBI says. So very recently, I think MasterCard, HDFC was denied issuing new cards till it was, then I think, they completed it. So my feeling is that, the present law is much, much simpler or, and much finer and much thought out. I think it may have some more, it may need some more modification. That's a different issue. But I think it is a much better version of what it was.
So just want to quickly respond on your last comment about data mirroring requirement. That's one of the RBI requirements for payment systems company. I think from a global economy and digital economy perspective, what we should be promoting is not where data is stored, but how it is secured from a privacy perspective, right? It's not the location of the data that should be important. In response to the issue of law enforcement access, as you said, to me it's also about how the data is secured and how quickly can that be accessed by law enforcement in any country. And for that, we already know that there are frameworks available, there are mutual legal assistance treaties available. So to me, as a business, as a responsible business, what we should be promoting is security of data, privacy of data, and not really where the location of data is. And it could be stored anywhere in the world, so long as it is secured through robust, as we say in the IT Act, reasonable security practices and procedures.
See, when you say it can be stored anywhere, I have no objection. When you say that, if I want to, security is most important. That goes without saying. There is no difference of opinion with that. When I'm saying that, I as a regulator, and assuming for a minute I'm a regulator, and I want to access to that data, should I go on a diplomatic route and, on a bilateral treaty and go there, and by the time, something can happen to the data, so quick action is there. And assuming that there is something wrong in it, what is my sanction I can give it to a country? I can't write to a sovereign country and say that, I want to do like this. The sovereign country's law may be different. For example, Basel III norms are there. Basel III is a universal law for the banking. But it also gives something that when you are finalizing certain Basel III norms for your country, you can have, you should have something which you can modify to the extent of what is necessary for your country. For example, the Basel III norms may not be ditto applicable for India. So India can tweak that, So that is why, see, if there is an easy method where I can access and I can put a sanction on them, you are right.
So you raise a very important point because when regulators or the police ask for data, a lot of the times, sometimes it's cross-border. Of course, within the same country, there's no problem. You have to give it. But when it's cross-border, it's very complicated. I've went through many requests by foreign police, not in Singapore, for data, but I'm not allowed to give because I'm a financial institution. So they have to go to the Singapore police and get the Singapore police to agree that there is a reason why this data should be disclosed. Because every financial institution is bound by their own regulator to protect the data. And it's a bit more complicated for Tazapay because we have subsidiaries around the world. But as earlier said, we say that our Indian entity doesn't keep any data. Anything they have passes through to the Singapore entity. And also, it helps that our Indian Indian entity itself is not a payment gateway, so it does not subject to licensing or registration for the time being. So coming back to, in all the crucial issue is you need to structure it properly. You need to make sure that your structure is sound. If it's not sound, you will have a lot of problems. Yeah, thanks.